Before we start, we would once again like to remind all participants regarding our house rules. Firstly, please familiarize yourself with Zoom app so that it is to ensure a smooth procedure throughout the conference. Secondly, please mute your mic to minimize interruption throughout the session. Thirdly, if you have any questions, please private message instead of public message to me, the MC. The questions will be forwarded to our speakers at the end of the session, and they will answer it at the Q&A time. Fourthly, please be mindful of your actions on camera, as all of us can see you on camera. Finally, please do not leave before the video conference ends to ensure minimal interruption throughout the session. For recording and presentation slides, it will be addressed at the end of the session. There will be no recordings allowed. However, for slides, it will be addressed at the end of the session, and we will be informing you how to get the slides. Today is day 3 of the L2 construction series. The topic for today is managing the impact of the COVID-19 outbreak on construction projects in Malaysia. We are honored to have 2 of our speakers, Mr. Loon, founding partner of Harry and Lam Partnership, and Mr. Leong, claim consultant of MAC Consultant. Please join us and welcome our speakers for today. Thank you.
Thank you, Florence, our MC for this webinar. Good morning, ladies and gentlemen. This is the 3rd day of the session of the same topic, which is managing the impact of COVID-19 on construction projects in Malaysia. For those of you who have actually participated in the first or the second day, I'm just going to tell you that we are going to rely on the same slides. Perhaps the delivery will be a little bit different, but please bear with us. Now, the movement control order, as you all know, has already been implemented in Malaysia. And the power was actually derived from Section 11 sub 2 of the Prevention and Control of Infectious Diseases Act 1988. Now, it came into effect on the 18th of March 2020, and it has been recently extended to the 14th of April 2020. Now, the effect of the MCO is that all businesses practically have to come to a halt, except for essential services. Now, at the time when the MCO was issued, many, if not all, were not clear as to the scope of the MCO. And therefore, after the implementation of the MCO, the government and the various departments of the government have actually issued various guidelines and clarifications. Now, the clarifications that related to the construction industry, there were at least 2 clarifications issued. One was on the 18th of March 2020, and the second one was actually issued on the 24th of March 2020. Now, in essence, what these clarifications say is that, in general, construction and renovation works are deemed to be non-essential services, and therefore, the operation of these works will have to come to a stop. Now, except, of course, there are certain exceptions, which is if there are ongoing works affecting the safety and security and the works which are deemed to be critical. Now, even though you think that the works are critical, it is not automatic that you can actually continue with the works on site. There are certain procedures that you have to go through before you can actually continue with the critical works on site. Now, one of the things that you need to do is to get a certification from the contract administrator or the SO. If you're working on a JKR contract, you have to get it from the director of the JKR or the SO to certify that certain works or the works are critical. Now, once it's done, it has to be assessed by PWD and also DOSH to deem it as critical. Now, having gone through this step, the contractor will still have to apply to the relevant departments of the Ministry of Works and or perhaps the state or the local authorities to get the approval for these critical works to be continued on site. It is not automatic, all right? Now, next slide. we go to the next slide. What are these critical works? Now, the Ministry of Works has actually issued a list of works which are considered to be critical works, and the list is not exhaustive, and it includes slope repairs, refilling of potholes, traffic management control, checks on machines, and so on, and other works which will pose a danger if not completed. Now, in essence, what it means is that these critical works cover critical maintenance works. This maintenance works needs to be continued, and or works which will actually pose a danger if they are not to be continued. So therefore, those critical works which may pose a danger or has got some safety issues that needs to be continued, these are considered to be critical works, and the local authority or even the ministry would allow these works to continue on site so that the safety issues are not compromised. Now, as I said, that the continuation of these critical works are still subject to the approval. You cannot just think that these are critical works and you, on your own unilateral action, go on with the works. You still need to get the relevant approval. Depending on the location of the project, you have to know where to apply to get the approval, either the relevant department of the Ministry of Works or the state or local authorities. As I said, depends on the location of the site. Now, next, the pertinent issues that arises from the MCO is this. What happens if the MCO is breached? Meaning to say that the works are not critical, or even if the works are critical, they do not get the necessary approval, but they continue with the works on site. So then they are said to have actually breached the MCO. Now, if the contractor or the employer is caught doing works on site, then works must be stopped immediately. It is actually not negotiable. It has to be stopped immediately. And therefore, on top of that, the contractor may also be compounded with a fine not exceeding 50,000. I'm sure that right after the MCO was implemented, it was actually published in a newspaper that two contract sites were issued with a summons, a compound of 50,000 each. So because they have actually breached the MCO by continuing with the works on site. Now, on top of that, they might also be liable to imprisonment not exceeding 3 years, or liable to both. Now, in addition, the contractor may also be exposed to a further fine of 1,000 ringgit per day if the offence is continued after the conviction. Now, this power to compound the contractors and or the employers is actually derived from Section 70, Sub 13 of Street Drainage and Building Act 1974. Now, next issue that is pertinent. You know, the contractors, because of the MCO, most of them cannot proceed with the works. Now, even if certain parts of the works are deemed critical, now the other parts of the works on the same site might not actually be able to continue. So therefore, there would be an impact on the completion of the works. Now, one of the things that the contractor would have to think about when perhaps applying for EUT or L&E, they have to consider what are the events that had happened that may potentially entitle the contractor to entitlement, time entitlement, and or loss and expense entitlement. Now, one of the events that is very certain is that MCO has already been issued. But is MCO the only event, right? Because you have to look at the contract. Even MCO can be considered as a ground to apply for an extension of time. It is likely to fall within the force majeure definition only, okay? So then if it falls within the definition of force majeure, most of the standard form contracts, as you know, even though you're entitled to time, you may be excluded from the L&E entitlement. So that's why it is wise for you to actually look at other potential events that may also constitute relevant events that entitle the contractor not only to time, but also to L&E compensation as well. Now, depending on the location of the site, I understand that the local authority have actually issued suspension or stop work order in compliance with the MCO. Now, if that happens, then you have to look at the stop work or suspension order issued by the local authority to see whether it actually falls under other relevant events apart from force majeure that would entitle the contractor to an extension of time. If yes, then you also have to consider, would that event under the contract also entitle the contractor to L&E as well? If yes, if the answer to both these questions are yes, then you have to ask yourself, to maximize your entitlements under the contract, wouldn't you actually, as a first ground, to rely on suspension or stop work issued by the local authority as a ground to launch or pursue your claims entitlement under the contract? Because it will not only entitle you to time, but it might also entitle you to L&E as well. Similarly, if there is a suspension instruction issued by the SO, then that might very well fall within the category where the contractor may be entitled to both time and also L&E. So my advice is that just don't jump the gun. And when the MCO is issued, immediately just go and apply for an extension of time without looking at the contractual terms. And then you fall into a category where you are only asked for time without thinking about the potential claim that you might be able to make under the contract, which is L&E. Now, of course, for those contractors who have entered in a contract whereby the contract actually covers all these three events as relevant events, entitling the contractor to claim for time and or loss and expense, then you would be very good, because then the contractor can actually capitalize on their, maximize their entitlements under the contract, and to act in a clever manner in launching its claims or submitting the claims to the consultants. Now, of course, whether the what is the scope of the contractors and entitlements, depending on the events which have happened, would also very much depend on the exact wording of each construction contract. Now, next. Now, I have actually listed out their general steps that the contractor should need to go through. In general, what the contractor should make sure that they have actually complied with the contractual requirements in pursuing their time or L&E entitlement claims. Now, because after all, the contract actually governs the rights and obligations of the parties, I suggest and I actually advise, urge all the contractors, just don't take an easy way and a relaxed manner and just assume that because MCO is known in the entire Malaysia that it has already been issued, then automatically you should be entitled to an extension of time without doing anything or complying with anything that is set out under the contract. Contractual procedure and mechanism for claims must still be complied with. This is important, because if an event has already happened, even though it's well known, and if you have not complied with the contractual procedure, there is a risk that you might actually lose that entitlement. Now, I have generally set out the three steps where the contractor should go through. Now, the first, as I said, is the identification of relevant events. MCO, suspension order, suspension instruction by the SO. Have all these events occurred in your case? If yes, then you have to go through the contract and try to, as I said, maximize your entitlements. Which of the relevant event actually gives you both time and also L&E? If that event actually gives you both time and L&E, you rely on it as a primary ground. But also, of course, in addition to it, you can add other grounds like MCO and also other grounds as well, without compromising your rights under the contract. Now, once you have identified the events, the second question that you have to consider is this: to what extent, under these circumstances, that I can actually claim for time and perhaps also the loss and expense? Now, like for example, the time that you are asking for is not limited to the 28 days. You should also include perhaps the remobilization, the time that has to be taken for you to remob to the site. But of course, as to the actual time entitlement, you have to demonstrate that the MCO effect actually impacted on the critical path of the program and the works. So this will have to be discussed further by my host partner later. Now, the third consideration that the contractor would have to take note of is what are the contractual steps that the contractor would have to comply with in order to pursue its claims. Now, depending on what contract form that you use, there are certain, in fact, many of the construction contracts actually provide for condition precedents. Like, for example, if there is a notification procedure, you have to file the notification of intention to claim for time and also loss and expense within certain time period. And if you fail to do so, then the contract sometimes will say the contractor will be deemed to have waived its rights to claim for those rights. As I said, so even though there is an event that actually entitles you to extension of time, but because you don't actually follow the contractual procedure, you might actually lose your entitlement under the contract. So beware, know your contract, know about the requirements for the procedure for apply for claims, and make sure you comply with it now. Now let's go to the next slide. Now, what this is, as I said, my 3 steps procedure, which I have listed out earlier. The first step is about the identification of relevant events. Now, a lot of people actually told me this. I think this is a misconception, that the moment that there is a COVID-19 situation and the moment the MCO is issued, it is automatically fall within the force majeure ground. I think that is a too simplistic view or position to take, because force majeure, this is not a matter of law, because it has got no legal definition, no definite legal definition as to what force majeure is, because force majeure is a creation of contract. To what extent the force majeure, the events that fall within the definition of force majeure depends very much of each wording of the contract. Some definition may define force majeure in a wider manner compared to other force majeure definitions in another contract. Now, I have actually seen one contract recently whereby they have exhaustively defined force majeure, and they include other grounds, but they did not actually include epidemics. Meaning to say, even there is a situation of COVID-19 like what is happening now, it actually does not fall within the definition of force majeure. And if it is actually not fall within the definition of force majeure, there is actually no ground within the force majeure parameters for the contractor to apply for an extension of time. So you have to look at the contract to see whether the force majeure definition covers your situation. Now, for example, in PENFORM, Clause 28.3a has got a wide definition on force majeure, which also includes governmental or regulatory action. Now, the moment you see these words, it actually includes MCO. It's a governmental or regulatory action. And the next term, epidemics. Yes, epidemics, if you look at it, it covers COVID-19. So that's why COVID-19 and MCO can fall within the definition of force majeure under the PENFORM. Now, in other contracts, it might not have such a wide definition, right? But then if there is no such wide definition, I suggest that you look at the definition to see whether there's a general description. If there is a general description, which actually opens up in a wide manner to cover many various events that is deemed to be an event beyond the control of the parties, then the COVID-19 and the MCO can be argued to have fallen within this definition, and based on it, you can actually apply for an extension of time. Now, next. The next thing I have, as I've said earlier, not only focus on MCO, focus on also other events which might have already happened that might also entitle you to extension of time, and also perhaps L&E, like the suspension or stop work order issued by the local authority or the contract administrator. If it happens, and if these 2 events are listed under the contract that entitle you to both time and also L&E, I would suggest that you rely on these grounds as primary grounds in your notification for your claim for your entitlements. But as a fallback position, to be safe, you would also include the COVID-19 or the MCO as the force majeure ground, but without prejudice to the primary grounds, meaning to say that your claim launch, you prioritize it on the suspension and the stop work order to claim both time and also L&E. But in the end, if this ground fails, then you can still fall back on the force majeure as a secondary ground to entitle you to extension of time. Now, this is important. You don't give up any of your right under the contract. You just launch everything, but you make it clear that you rely on the suspension or the stop work order as the primary ground because it entitles you to both time and L&E. So if you fail, then at least force majeure is a clearer ground for you to get an extension of time. With the extension of time, at least the contractor is relieved from liability of liquidated damages. Now, I've actually covered my first step of identification of relevant events, which may entitle you in principle or under the contract to an extension of time or L&E. As to the extent of the claim that you can make and the procedure, I will now pass the mic to my host partner, Hong Kit, to elaborate further on this.
Yes, thank you, Loon. Good morning, everyone. This is L2 third day video conference and also the last day for this particular topic. So far, the feedback we have received is positive, and this is what drives us continue to do further, which me and Loon are excited to do. I'm going to talk about the practical guide to managing potential claim with you. As we now already know, construction works are not essential services. So only critical works that have been approved by relevant authorities are allowed to continue. This then creates a scene with two different scenarios, whereby the first scenario is construction works that are not listed as critical works or have failed to obtain approval to continue. And the second scenario is critical works that have been approved to continue. Let's start with the first scenario, which I think is the current situation for the majority of the construction projects in Malaysia. If the works are not allowed to continue, what should one do? You don't call your contractor's friends to ask for advice to apply for EOT or loss and expense, because most likely they are using a different form of contract or having a totally different situation or circumstances. The first step is go back to your own contract and see what the contract has to say. Before going further, I also want to elaborate a bit. The purposes of a contract are not only to set out the contract price, duration, and scope of work. It is also a mechanism to allocate risk between the contracting party. When it comes to COVID-19 or MCO situation, most people would think only of force majeure clause. It, however, may not be the only clause under the contract that covers this situation. Depending on the wording of the contract, a contractor may also want to look at suspension of work or the requirement to comply with statutory direction, such as the current MCO, to claim for extension of time and loss and expense. It must be emphasized that the coverage and effect of these clauses are subject to the wording used in the contract. To illustrate this, if a relevant event labeled under suspension of work has expressly excluded neutral event, such as the MCO, it then cannot be relied upon by the contractor for the present situation. Just for clarification, a neutral event is an event that impacts on the completion date, but are not the fault of either of the contracting party. So locating the suitable clauses are not the end of the story yet. Even if the clauses cover for MCO period, this does not mean the contractor is automatically entitled to extension of time nor loss expense. Of course, the procedural requirement must be followed. Under PAM, you actually have 38 days to submit the first notice. If you haven't done so, submit today. You are still safe, not out of time yet. But even that, that's still not enough. Do you know why? Okay, because as my step 2 here concerns, the contractor has to demonstrate the MCO event actually has caused delay to the original completion date. Bearing in mind, not every delay is a delay to the completion date, and only delay that affects the critical path can be considered for extension of time. So how do we know whether a delay event affects the critical path or not? We don't play with assumption here. There's actually a contractual instrument called baseline work program, which can help us to find out whether an event falls under a critical path or not. Just look at the slide here. I put a hypothetical work program. Is created to show what is not an activity that affects the critical path. As you can see here, even if the red activity starts after the MCO is lifted, it would not cause to the it would not cause delay to the original completion date. I know this is not a normal work program, but it's just for demonstration purpose. In this situation, even supported by express contractual term, the contractor would not be entitled for extension of time. Let me quickly give an explanation of what is a baseline program. The baseline work program is a detailed view of how they will divide all the works under a contract into activities, the duration of those activities, and sequences of activity. The program should be practicable, realistic, showing when the contractor intends to carry out each part of the works and identifying the time they require. Here, a work program for building a wall would generally look like this. It has activities for bricklaying work, plastering work, and painting work. Here, the plastering work was supposed to be carried out during the MCO period, but it could not for obvious reason. When the plastering work will resume after the MCO was lifted, as you can see here, the completion date would remain the same. It's not affected. Therefore, the MCO event, though caused delay to the completion of the plastering work, but it did not cause delay to the completion date. So the contractor would not be entitled to any extension of time. Now, assuming there is a clause that allows the contractor to claim for extension of time and the MCO event is proven by delay analysis that it causes delay to the completion date, the contractor will be entitled for extension of time, provided that the procedural requirement has been met, of course. However, this does not give the contractor an automatic entitlement to claim for loss and expense. Most people I talk to assume that if you are entitled to time, then you are entitled to additional cost. This is untrue, as they don't come in naturally in pair. It is very often that despite time for EOT is allowed, but cost for loss and expense is not. The contractor's entitlement to claim for loss and expense is is subject to the wording of the relevant clauses. For example, if the clause has excluded MCO event, even though the contractor is entitled to time, it will not be entitled to loss and expense claim. This is the case in PAN contract where force majeure allows for EOT, but not loss and expense. Okay, now even we have a loss and expense clause that allows the claim. The next question is this: how do we compile a loss and expense claim? I have often been asked by contractors whether loss and expense for prolongated period can be claimed by apportioning the preliminary cost in the PQ or not. Meaning to say, if the total preliminary cost is, say, 12,000 for a 12-month project, then the prolongation cost for each month would be 1,000. What do you think? Yes or no? Whilst the contract preliminary rates will include estimated costs for site establishment, management, supervision, overheads, profit, and equipment that were anticipated to be required on site for certain durations and may well have affected by the overrun of time. However, this is not factual and does not reflect what was actually incurred during the prolongation. My advice is this: go ask your accountant, analyze your SQL, MYOB, or UBS, or other cost report, and ascertain the actual additional costs incurred as a consequences of the time overrun. Bearing in mind also, not all costs can be recovered, however. I have listed out the potential claimable costs for your reference. So for direct costs, it has labor costs, plant and equipment, subcontractor costs, and also site overhead. The identification of direct costs is best achieved through site diaries or daily reports. Associate items such as vehicles and office space usually follow on if the individuals involved can be identified. As for direct costs, it covers costs of head office staff and rental and utilities payment on the head office. These are the costs incurred by a contractor as part of its normal business operation on for the project. The entitlement of a contractor to recover indirect costs is not always easy to determine. This must be bear in mind. We may also want to consider finance costs, as a lot of contractors are normally operating on bank finances facility like factoring loan, overdraft, term loans, and etc. etc. Now, we have covered all the steps necessary to make a claim under this scenario 1. However, it still have to be properly prepared for the other party to be able to assess the claim. You can't just dump everything into the claim and ask for a figure 100,000, 100 million. No, this is a global claim and it is not easy to succeed and not advisable to do it in such a manner unless there is really no other options. You see, if you fail to substantiate the claim, the probable consequences is this. Despite establishing the entitlement to claim under the contract, you may only be entitled to a nominal amount, a small sum. Okay. This is a wide topic. Due to limited time, we won't be sharing with you on the topic of how to prepare a claim, but we will be having a sharing session on this coming Friday, same time, with another guest speaker. We welcome you to join if you are interested to know more about claim preparation. So we have now arrived at the 4th step, which is mitigation. The idea of mitigation is this. Even if the contractor is entitled under the contract to make extension of time and loss and expense, the contractor must still take reasonable steps to minimize or mitigate its loss and must not take unreasonable steps that will increase its cost. For example, during MCO, a contractor cannot suddenly include more idling workers or machineries just for the sake of claiming additional costs under loss and expense label. This would never be allowed. So the steps I have just discussed are related to scenario 1 when the construction works are suspended. Just for a quick recap, step 1, go back to the contract to see what does the contract say. What provisions allow you to claim in this situation and what can be claimed. What are the condition precedents? What are the procedural requirements? Then look at step 2, whether the MCO actually affects critical activities on critical path. If it's not, the contractor has no claim. Then step 3, identify the heads of claim, keep proper and contemporaneous record to substantiate the claims. Step 4, always take reasonable steps to mitigate or minimize the loss. The concept of claim, the claims are divided into 2 basic parts. Entitlement, which is the determination of whether the claim has merit or basis. And the second, quantum, which involves a determination of how much money or time the contractor is entitled to receive. Just as I said earlier, if you establish the entitlement without establishing or without substantiating the quantum, you would be only allow a nominal amount. Step 1 deals with the contractual entitlement, while step 2 deals with the factual entitlement. And steps 3 and 4 are relating to quantum of the claim. These steps, they may have overlapping between the entitlement and quantum somehow. We will now look at scenario 2 where critical works are approved to continue. If a contractor has received approval to resume works, it must comply with all directions set out by relevant authorities and the contract administrator, the project director, SO, or the architect. However, it must be emphasized that it is not the type of situation where the contractor resumes different works under normal circumstances. The approval here is subject to current situation, hence current directions issued by authorities. For example, the approval obtained may be subject to conditions like working hours, working day, or even a specific method of the execution of the critical works. These conditions may incur additional costs for the contractor, and the contractor should look to the contract to see whether those conditions have constituted to variation order. Just for example, the definition of variation under PAM contract is posted on the slide here for your reference. Therefore, once the contractor receives the architect's instruction to continue works based on the approval obtained, and when the approval obtained somehow carries a condition of, only working 2 working days, 2 working hours, or 2 working days, yeah, or some part of the site is closed, or the accessible is being more difficult, hence affecting the ordinary working day, hour, and also working space of the contractor. This may entitle the contractor to claim for variation order. Also, similar to extension of time application to effect a variation order, the contractual requirement must be strictly followed. I have already covered the 2 possible scenarios. It's time for me to pass the mic back to my host partner, Loon. Loon, please.
Yes. Well, ladies and gentlemen, we have actually covered the potential entitlements under the contract arising from the MCO and also the COVID-19. And Hong Kit has actually gone through in brief what are the steps that you might need to take in order to substantiate or apply when applying your claim. So now the thing is that there is another related topic, is that if there is a COVID-19 situation and the MCO has already been issued, would the contract be deemed to be frustrated? Now, generally, a contract is said to be frustrated if there is a supervening event which happened subsequent to the formation of the contract, whereby the performance of the contract has become impossible or rendered unlawful because of the perhaps the MCO or the COVID-19. Now, not every situation would render the contract being frustrated, because especially in such a situation whereby the contract has already provided for such an event, meaning to say that the parties in the contract has contemplated the possibility of happening that event, and it has been dealt with under the contract. Like, for example, the extension of time clause force majeure that is provided in the PAM form. Then you cannot be said that the contract has been frustrated, because the contract has already has a provision to deal with that situation. In such a situation, the court will actually look at the contract and enforce the contract and give effect to the contract. And that is because the parties have actually foreseen that event in the contract, and they have taken the liberty to allocate the risk accordingly, according to the terms of the contract. And in such a situation, the contract cannot be said to be frustrated, and the court will enforce the term. Now, let's say that there is no such provision dealing with such an event in the contract. It was not contemplated by the parties at all. And the happening of COVID-19 and also the MCO has actually rendered the entire contract or the balance part of the contract to be impossible to perform, or has been rendered illegal to perform. Only in such a situation, then you can say that the contract has been frustrated by operation of the law. Then if that happens, Section 57 of the Malaysian Contracts Act has actually laid out what happens if a contract is frustrated. That is, in general, if a party has expended cost or expense in the performance of their contract up to the date of the frustration event, then the other party, if he has benefited from such the performance, he has to compensate the other party for the cost and expense incurred up to the date of frustration. Now, this issue, when it is referred to court, it will be determined by the court basing on the evidence on the actual expenses that has already been incurred, and they will also look at the terms of the contract and decide what is the reasonable reimbursement of those costs within the parameters of the contract. Now, this doctrine of frustration, as I said, the effect of it would actually depend on the wording of each contract and also the scenario. Now, perhaps the more important question that we should deal with is, what are the practical things that we should take note of when the MCO is being enforced at the moment? Are we going to just stay at home not doing anything and wait for the MCO to be lifted? I suggest not, because during this time, both Hong Kit and myself have taken the liberty to interview some of our clients, and they have actually given some suggestions and the things that they say that they are doing at the moment, which I think is very productive. Some of you might, even take note of it and try to adopt it during this MCO period. Now, the first thing, of course, that the employer and also the contractor would need to do is to ensure that the site is safe and secure and everything is in compliance with the MCO. Now, the workers must also adhere to the MCO strictly and also adhere to the highest level of hygiene standard. This is because you do not want any of your workers to be contracted with COVID-19. And if one of your workers is contracted with COVID-19, just imagine that the clusters of people who have been in contact with this worker would also be quarantined. And if that happens, even eventually the MCO is lifted, you are not, or you will not be in a position to start the works at the optimum level or as it should be. Now, even some of my clients have taken the steps to, or active steps to have their workers subjected to the COVID-19 testing. That is because if it is true that any one of them is actually contracted with COVID-19, they might as well just deal with it now during the MCO period, rather than wait until the MCO is lifted and only to find out that one of their workers is contracted with COVID-19 testing. This is part of the risk management. Now, I'm going to pass back to Hong Kit to deal with the other practical issues as well.
Thank you, Wai Loon, for the sharing. In addition to that, I think the contractor must ensure all the machineries are in operational conditions by having a periodical check, inspection, and warming up to prevent flat battery or flat tires. This is to avoid when the works resume only to find out that the machineries are not in a functional state. Also, during the MCO period, it is very, very important that discussion and communication continue to flow. This can be done on electrical forums such as WhatsApp, Skype, or Zoom, which we are using now, so that decisions can be made, directions can be given to the project teams or relevant person to keep documentation in check. As we all know, and we have learned that contemporaneous records are crucial for preparation of claim. The contractor must also have to anticipate and plan for the resumption of works when the MCO is lifted. Salary reduction or deferment can only be done within the parameters of the government's directive and the law. As of the current directive, without the consent of the employees, salary reduction or deferment cannot be made. I think any arrangements of this sort is better to resolve by open and honest discussion between the employer and the employees, so that a win-win situation agreement can be reached between the parties, between everyone. That's it for me. Is there anything you want to add?
Hong Kit, I have nothing to add. I think now is the time for us to deal with the questions which have been posed by the participants so far to our MC. Now, we should ask the MC to direct the questions to us, and we will go through the questions and we will try our best to answer those questions.
Thank you.
The next
We
slide.
have collected.
Yes,
Thank
Florence.
We have collected all your questions throughout the conference session. Now our speakers will be answering said question in this Q&A session. Please once again welcome Mr. Lam and Mr. Leong. Thank you.
Thank you, Florence. I have received it through the chat that you have just forwarded to me. I'm going through some of them. As I said earlier, even in the last two sessions, we wouldn't have the time or enough time to answer each and every question. No, so we are only going to pick some of the questions which we think are interesting for us to share our views in this forum. Now, one of the questions I think this is very interesting. Actually, what happened is that the participant has alluded to us is they have the consultant has actually issued the payment certificate for the works done before the implementation of the MCO. Now, before the expiry of the due date for payment, the MCO was implemented. So therefore, the due date of the payment certificate for payment falls within the MCO period, and the employer is actually using the reason that there is actually no one is working in the office, and therefore the payment cannot be processed during the MCO period. Now, what would happen is that would the MCO period be considered or would it be excluded from the calculation of the due date for payment after the certificate has been issued? Now, without naming which contract form, assuming that it is PAM form, I think section 30, the default position is that the employer will have to make payment within 30 days upon the issuance of the payment certificate. And if it happens before the MCO is implemented, whether the MCO period of 28 days should be excluded from the calculation of the certification payment date. Now, I think if you look at it from the contractual point of view, I don't think that the MCO period should be excluded. If it falls due within the MCO period, it remains due at that point in time. So meaning to say that once the MCO is lifted, you can immediately ask the employer to make payment, because they would now then at that point in time to be in the position to process and make payment to you. Now, let's say if you're considering to pursue it further, if the employer fails to make payment and you are eager to start a SIPA claim and launch a payment claim against them. Now then, if that is the situation, you have to consider it in a different manner, because as you all know, when it comes to legal argument, lawyers would be able to think of all kinds of arguments to try to defeat the claim. And one of the things that they might actually argue is that because of this MCO period issued by the government, it should not be included within the calculation of the payment due date for after certification. So then they would actually try to launch it as a jurisdictional challenge and say that your demand for the payment is premature under SIPA. Now, whether or not it is sustainable is besides the question, because you do not want to end up in such a situation where you have to deal with this jurisdictional issue and go through the 3 levels in court and takes years and monies for you to resolve. So if you are really thinking about going for SIPA in such a situation, I would suggest that to make your case clearer and to avoid having had to fight this legal question in court, just exclude the MCO period so that there is no legal argument or potential argument that the other side can actually launch to try to delay further payments to you. Yeah. Hong Kit, do you have any other questions that you would like to address?
Yeah, I got a question from a QS consultant asking us if the QS consultant is required to continue valuing the contractor's works done during the MCO period. This is a very good question. As I said during yesterday's Q&A section, contractual mechanism continues to operate even during the MCO period. Nevertheless, make no mistake, common sense must prevail. The QS consultant is not allowed to enter the construction site during this period. Hence, valuation is impossible. I would say that the QS consultant should proceed to conduct valuation as soon as the MCO is lifted. Just a piece of further advice, if any party wants to take a claim to SIPA, when calculating the certification period for payment due date, just to be safe, the MCO period should be excluded from the calculation. I can see there is an overrun of time now. I think I should pass the mic back to our MC Florence. But before that, I want to thank you everyone for taking part in this session today. I know some of you have been with us since Monday, listening to us discussing the same topic. So I would like to let everyone know that starting from tomorrow onwards, every morning at 11 a.m., we will be having different special guests coming to L2 Construction Series platform to discuss a range of construction topics. Be sure that Wai Loon and I will continue to do our best to make the contents as interesting and as useful as it can be. We have put a lot of time and effort into creating this L2 Construction Series, spent a lot of time discussing so that we all have a platform to share ideas, gain knowledge, where all of us can benefit, especially during the time of MCO. If you find our discussion is useful, please leave us a feedback, as it can always help us to become better. Okay, also continue joining our future section. Thank you. Florence, I'll pass the mic back to you.
Thank you so much. So can we have the next slide, please? Thank you. So we would like to express our gratitude to all our participants for today's video conference. As you can see from the schedule displayed on the presentation slide, we have prepared a series of web seminars with a lineup of esteemed guests. And as Mr. Leong has mentioned, on Friday, we have a special session at 11 a.m. for more sharing purposes. So there will be more L2 series thereafter. For more information, please contact our friendly client support managers via WhatsApp. And then you can scan the code on the presentation slide for registration. And the updates for the conference talk and producing videos are daily. So for those who are interested, please do check out our social media platform for more information. And we noticed there were many audience who are not registered today, but we welcome them as the video conference is all about sharing knowledge. But however, the reason we want you to register is that we can keep in touch with you for more updates. So please do register with us and scan the code. Thank you so much, and we'll see you again in our future events. Thank you. Thank you, everyone.
Thank you.
Thanks.
All right.
I will leave the slide on for a while for the participant to have a look. Okay.
Yes.
Thanks, everyone. Thank you again. See you again. See
Thank
you,
you,
Wai Loon.
everyone.
See you, Florence.
Bye-bye. Thanks, Florence.
Thank you.
Bye-bye. Thanks, Ongkit.